So this particular FMA panel it's a unique one. It's the first of this kind where I'm actually lecturing. Usually we'll have a panel. We've started getting into the digital component as well, where I will interview colleagues via an online platform. So we're starting to get into that. Now we're doing Periscope. Hey guys. Something that's really interesting is that I've had students who are interested in being a music lawyer kind of pursue that path or look to pursue that path, but they really don't know what a music lawyer does. And I actually met with a very lovely young lady yesterday who thought maybe she wanted to do entertainment law. She's graduating from law school, but she thought maybe she wanted to go into management, but she really wasn't sure what it is that she wanted to do. And then I was telling her about what it is that I do on a daily basis, and she seemed to be very surprised. She was under the impression that a music lawyer is someone who practices criminal law, maybe business law, maybe tax law, who happens to have an entertainer as a client. That could happen, but what I told her is that every day I am involved in musically driven initiatives and deals, and she seemed to be very fascinated about that. So I think today it's timely because I'm going to tell you all what it is that I do, the kinds of things that I work on. I am a transactional entertainment lawyer specifically in the music space. I do all music stuff, no litigation. My thinking is by the time we're at litigation, it's conflict. I'm here for all creation. So we're going to actually walk down a path of intellectual property, what the deals are, and then we're going to get into the murky waters of music streaming. So there are 3 things in the music space that I deal with, and it's going to be copyright, trademark, and personality rights. These 3 rights are at the core of music law. Copyright is going to be with respect to the music. Trademark and personality rights are going to be with regard to the brand. So I always like to say, and to make sure people understand, that copyright is the staple of the music business, and I like to have people repeat that. So copyright is the staple of the music business.
Copyright is the staple of the music business.
Thanks, guys. That was beautiful. And then we start dealing with trademarks and personality rights. Trademarks are going to be stage names, and maybe some sort of slogan or saying. So a stage name, DMX, Metallica, Grateful Dead. Slogan, Nike's Just Do It. I can't remember which fast food restaurant it is, Have It Your Way. Those are going to be trademarks. And then personality rights, this is going to be name, image, and likeness. And all of these rights are recognized in law, which is why you have lawyers who oversee these things. Copyright in the United States is acknowledged in the Constitution. Trademark is acknowledged. Personality rights are acknowledged. As people, we do have the right to privacy. We do have the right to control our name, image, and likeness. So these are the 3 fundamental property rights that I'm dealing with as a music lawyer on a daily basis. But what does that look like in real life? So with copyright, we're dealing with recording deals. We're dealing with music publishing deals. And we're dealing with music licenses with regard to copyright. With regard to trademark and personality rights, I am dealing with endorsement deals, merch deals, sometimes appearances, and there's a whole host of other deals, but these are the main ones. Does everybody see how you have these rights and how they're reflected in these deals? Yes, ma'am.
What about artwork? Is that something you deal with under copyright as well?
Yes, so artwork, I'm dealing with artwork mostly when it comes down to papering the album. If there is cover art, nowadays just with the digital sales, it's really lacking. But what we will do for cover art is we will do a work for hire so that we can get the copyright. Great question. Any other questions right now?
Yes, I have a question.
Yes.
For trademarks for a saying, how do you show that they're using that like in commerce? If it's like, trademark, like if it's like Trey Songz here, that, like how do you show that that's...
So with the trademark, there's kind of two different bases that you can apply for a trademark on. It's an intent to use and an actual use basis. But what that slogan or that saying has to be, it has to be in reflection to a good or a service. And we have trademark protection so that people who are in essence building a brand, they can make sure that they're building that brand and that people aren't coming in and kind of infringing with something that's similar, because when people build their brand and people consume it, it's a trust factor. So with your Trey Songz, maybe if he's putting it on a t-shirt, maybe if he's putting on lunch boxes or stationery, perhaps he then has a position for a trademark, which is kind of in a song. Something that I like to say when you think of the Nike, the check mark, that's not necessarily it, but you get what I'm saying. Or just do it. Both of those are trademarks. But when we see these trademarks in real life, it's with respect to sneaker, shorts, shirts, and that is the good that they're offering. Thank you. You're welcome. So with copyright being the staple of the music business, I definitely want to just dive into copyright. Because copyright is the reason why we're here. So I gave you a lovely handout. And actually, this is a page from my workbook called Don't Forget About the Music. And in the workbook, there is this breakdown. There's a whole chapter on copyright. And so what you'll see here, and this goes for a recorded song. So when we start getting into music, it's like, okay, I understand that copyright is related to a recording agreement, a music publishing deal, a music license, but like seriously, what does that mean? So this is where we get into copyright. For every recorded song, there are 2 copyrights. That first right, copyright, is the composition. And the second one is the sound recording. And as you can see on that handout, what the composition is, it is the music and the lyrics. And here, this is the actual recorded sound of the song. This is also called the master. So when we talk about the master, it's exactly how it sounds on the radio, the recorded sound of the music and the lyrics. So for every record, Rihanna record, Beyonce, Metallica, Grateful Dead, there's always going to be 2 copyrights, always. And you'll see that reflected on the worksheet as well. And why is this important? It's because if you are a songwriter or a producer, you have a copyright. If you are a producer or a recording artist, you have a copyright in the master. And so as having a copyright, that means that you have exclusive rights. And you'll see on the worksheet what those exclusive rights are. The exclusive rights to a composition is the right to reproduce and make copies, the right to distribute, the right to publicly perform, the right to create a derivative, and the right to publicly display. What does that mean in real life? The right to reproduce and make copies and distribute. If you are the copyright owner, you have the right to say, I do not want my work to be reproduced and distributed, or I do want my work to be reproduced and distributed, and that's what we're dealing with in these agreements. When we talk about compositions being performed on the radio, that's a public performance. You have the right, the exclusive right, as a copyright holder to say whether you want that to happen or not. Yes?
Could you talk a little bit about absence of an agreement, the default situation for copyrights when there's co-writers and things like that?
Yes, absolutely. So let's say that I have created a song, I've written it, and you've produced it. The default law is that we are joint owners in the whole. So even though I've written the music and you've produced the composition, you don't just have rights in what you produce, and I don't just have rights in what I've written. We jointly have rights in the whole, and if we don't do split sheets, it's an automatic, it's an equal divide. But if we decide, that you're gonna have, 35 and I'm gonna have the balance, that's what we would need to agree to, because the way that the law works from a default standpoint is that we are joint owners in the whole and equal shares. Convenes. And so on this side, if you are the performing artist, your voice is on the recorded sound, you are the producer, you help to create the recorded sound, you're gonna have a copyright in the master recordings. So to use our example, if I've written a song, EGK is the writer, Wesley is the producer, we're going to say Dana is the singer.
It's not making much money.
Put a little auto-tune in there, get you a little vocal production. We'll work it out. So we all have created a song, and we're going to name that song Star, because Dana's a star. So we all have, well actually, myself and Wesley, we have rights in the underlying composition. If Dana didn't write or contribute to the composition, she does not have a copyright in the composition. On this side, when we talk about the sound recording, the master, Dana has copyright ownership. Wesley has copyright ownership. I do not, as the songwriter. And so let's say, for instance, Star is actually a really good record. We got your vocals to sound pretty good. And let's say that MAC Cosmetics, they want to put the song in one of their commercials. So we know that because we are the content creators and we have these exclusive rights, we know that MAC Cosmetics does not have the natural rights to be able to use that song. So what MAC has to do, it has to get a music license from us. That's the case if a video game wants to use the song, if any brand wants to use the song, if they want to put it in a film, there has to be a music license. And what happens in that music license is they say, hey, we'll give you $15,000 to exclusively use the song in our commercial for 6 months. And you're going to grant us the rights to be able to do so because you have the exclusive rights when it comes to the use of that composition. Then we have to have another license. So MAC has to get 2 licenses. Does anybody know why they have to get 2 licenses?
They need the rights to the master and to the song.
That's right.
Publisher and label.
Absolutely. So remember, every recorded record, there are 2 copyrights. And if MAC wants to use Star, MAC has to get authorization for this copyright, and they have to get authorization for this copyright. So we're just going to assume at this point, Dana, myself as the writer, and Wesley, none of us have publishers or labels that we're committed to. We're out here, we're independent, we're going strong, we're doing everything ourselves. So these licenses will come directly to us to agree on what those terms will be. So what Mac may say is, listen, we want to pay 15 all in for both of these rights. We may say, you know what? We want 15 for this. We want 15 for this. You know, it's subject to negotiation. The bigger the song, absolutely. We're independent. 15 might be good for us, but if I'm your lawyer, I'll push a little bit more. It's Mac, right? And it's a good song. It's a good song. So that's what we're talking about with music licensing. It is another party, another entity coming and saying, listen, we like this record. We want to use this record. And because we know that you are the exclusive rights holders, we need something from you in order to use it. And we're going to figure out what that use is. We're going to figure out what that fee is and how we can use it in a licensing agreement. We got that? All right, so now we start getting into recording agreements and music publishing. So we're going to do recording. So Star takes off. Dana is just popping. She is just performing all over the place. She's really in high demand. And let's go with record label Y wants to sign Dana. Well, what record label Y understands is that whenever Dana performs on a record, she is the natural rights holder. If you're a record label, you are in the business of reproducing and distributing sound recordings. We know from our handout that reproduction and distribution is an exclusive right that Dana has. So at the core of a recording agreement is how are we going to get the copyright ownership from Dana so that we can be the authors, the owners of the sound recording to do whatever we want to do with the records. And that's where Dana and her lawyer, they get into, okay, we're going to consider this deal. We want an advance of X. We only want to do, an album commitment of Y, and then we're going to get into what the royalties are going to be. The label might ask for merch. They more than likely will. They're going to ask for merch rights, subject to negotiation. They might ask for co-pub rights. If the label is more of a production company, what I found is that they will generally ask for co-pub rights. What I found in my dealing with major record labels, they usually don't ask for this because they usually have a publishing arm. So Warner Records, Warner Chappell, Sony, Sony ATV, Universal Music Publishing Group. And then you get into the 360 component, also known as the ancillary. And that's when the label will say to you, Dana, we love you. We love this record. We want to make you a star, actually. So we're going to give you some money. We're going to put all this marketing dollars behind albums. We're going to give you some royalties after you've paid back all the money we've given you. But because we're going to make you a star, we're going to put you in position to tour, get more endorsements, get some appearances, become this brand, and we want to participate in that. Anywhere from 5% on some levels, all the way to 25%. And there's a bunch of negotiation that happens in there. But remember, at the core of this deal is the ownership of the copyright. Absent this right that Dana has as a recording artist, none of this happens. This is just the terms on which they're going to get that copyright from her. Now, on a songwriter and producer standpoint, let's say that Dana enters into this deal. I'm her lawyer, so she got a good deal. They want to take Star and they actually want to distribute it on the label. So they got the rights to this from Dana. But they then have to get the rights in this copyright here. What you'll see from a label standpoint, from label Y will not want to own this. And let me just clarify even more. This is known as the publishing rights. Label Y will not ask the writer and the producer to own the publishing rights, but because these rights are underlying to this recording, they have to get the authorization to redistribute, to reproduce and to distribute. And they do that through a mechanical license. So label Y says, hey, we're gonna put this song on this album, we might even put it out as a single. We recognize that you all wrote on the record, and in order for us to reproduce and distribute, we understand that you all have the natural rights to it, and we also understand per the law, there is a rate that we have to pay you every time that we distribute. So then there's a form, and you talk about what the mechanical royalty rate's gonna be, if it's gonna have any restrictions to it, if it's gonna be controlled. And let's say the album goes out, it does well, Star is a single, it's making money all over the place. And then let's say album does well, then the writers, which would be myself and Wesley, as a songwriter producer, we then get a check for our writing on the Star record. Now let's say that this record is huge, myself as the writer and Wesley as the producer. We're getting all this demand, we're in studios everywhere, we're writing, we're producing, we're making all kind of music. We're getting hot, we're popping a little bit. And so we start getting offers from music publishers. Let's see if we've got any more room. We get so in essence, a music publisher is kind of like, it's the same relationship as a record label to an artist, music publisher, songwriter. And producers are also considered songwriters. So the music publisher will say, we're going to do scenario 1 for Evita from publisher A. Hey Evita, we absolutely love you. We want to be in business with you on the publishing side. But because we know that whenever you create a composition, you have rights that are natural to you, we want to be in business with you and get those rights from you. And I might say to publisher A, I'm not really looking to be in a deep relationship with a publisher, but I do need someone to administrate my publishing. And they may say, okay, you've got enough going on. We want to be in business with you with that respect as well. And so with an admin, we're going to go publisher admin. Evita gets to keep her copyright, but she's going to give over control. And she's probably going to have to pay up anywhere from 10 to 20% of revenue. This publisher says, okay, we want to be in business with you. We don't want to own this. We just want to control it in the sense that we want to be in position to go out and pitch your music, be able to execute licenses on your behalf. We want to collect the money. We want to be in control of what happens with the composition, but we don't want to own it. And this kind of deal, we're probably going to look at X firm number of years. But Wesley gets approached by publisher B. Publisher B wants to be in deep business with Wesley. And they're actually, they're willing to come up with a little bit more money. So they're going to offer him a co-pub deal. Now in the co-pub deal, the publisher is going to ask for ownership of the copyright to the tune of about 50%. And they're going to pay a little bit more money than what Evita got, maybe. And then what you're looking at here is also the control factor. They're saying, Wesley, we understand that when you create a composition, you have these natural rights. We want to jointly own those rights with you. Ultimately, we want to control the whole thing, though. We're going to give you more money than what you would probably get in an admin deal, maybe. But these rights are going to last a little bit longer. Music publishing is the cash cow of the music space, and it is one of the most complex things in the music space. But generally what you'll see is an admin deal, and you'll see a co-pub deal, and hopefully this is just enough information to kind of, explain to you what the differences would be in those. Any questions at this point? Yes.
Aside from like the monetary differences and the length of those deals, what would be just other pros and cons that you can immediately think of just from real life experience?
I always recommend for songwriters and producers to seek the admin deal. Because as a songwriter and as a producer, until you're reaching the position of getting endorsement deals and Beats by Dre and all of that stuff, this is your thing. You're not necessarily doing tours and appearances as an artist would. This is your only property. And so once you start to divvy it up, you aren't necessarily going to get it back. So I highly recommend an admin situation where perhaps you've got so much going on, you do need administrative support, and you're willing to give up a piece of the revenue for that. I like that because we know in X amount of years, 3 years, 4 years, sometimes even 2 years, provided that you're recouped the advance that they paid you, you can walk away from that deal. Now your records don't necessarily, your compositions don't necessarily go with you, the ownership does, but their right to kind of administer may last an extra year or two after the deal is over. But 20, 30 years from now, you've got a catalog that you still own. And you were in business with an administrator who helped you kind of grow because you couldn't do it on your own as far as the licenses and things like that. On a co-publishing side, really people are attracted to these deals because of the money in comparison to an admin deal. But nowadays, if you haven't built up a significant catalog or a catalog that's moving, what a publisher is going to offer you for a co-pub deal, the value is just not going to be there, in my opinion, for what they're getting, which is essentially half of your copyright. And maybe you'll get that back in a reversion 15, 20 years down the road, subject to recoupment. You certainly can negotiate for that. I think one misconception that a lot of people have is that a publisher is going to get them placements. Out of all of the pub deals that I've done, co-pub, admin, majors maybe on an independent level, nobody ever makes a promise to secure opportunities for you. But a lot of people think, just like with getting a recording deal, in order for me to make it, in order for me to become who I want to be, I have to get a recording deal. I have to get a pub deal. And I think what happens there is that if you were growing up and you loved music and you were a music connoisseur, the people that you loved were probably in a recording deal. The songwriters and producers that you loved probably were in a pub deal. So I think a lot of people pursue these things believing that it will make their career. I'm a big believer you get a recording deal, they give you, significant funding, that's great. You still got to do the work. Got to do the work. On a publishing side, you enter into an admin deal or a co-pub deal, you got to do the work. I think a lot of people enter into these, specifically a co-pub deal, and they're very frustrated. My publisher isn't giving me any opportunities. My publisher isn't getting me in the room. My publisher isn't securing, placements for me. And so, well, there's nowhere in your agreement that says that they will, and they will not put that in there. So I think that frustrates people. When you look at big publishers like a Warner Chappell or Sony ATV or Universal Music Publishing Group, they've got their P writers, but they've got thousands of other writers, like a whole bunch of them. You've seen it's like a whole roster of them. People you never heard of, people who had one hit, people who may have had potential, but then they signed a deal on a fraction of the value of what they're actually worth over time. And you think about it, if you're in a big publishing system and they're in the business of making money, if they are securing opportunities, who are they securing it for? It's going to be their top writers. So, it's something to think about there. So like I said, as a songwriter and as a producer, this is your thing. This is the thing that will feed your children and your grandchildren, if it's done properly. So I've got a whole spiel about that. But that would be kind of my pros and cons.
I'm sorry.
Okay, go ahead. You can follow up.
All right. Well, I was just going to say, for those bigger deals, just typically how long do you think they really give a producer or songwriter to kind of show their worth? You know what I'm saying?
Well, what happens in these deals is that they say, let's say you have a producer who's got a record that has some sort of traction. It's still growing, but it's visible. People can kind of feel it and see it, and maybe this producer actually has some sort of talent. The co-publisher will come in and say, listen, we want to be in business with you. We're willing to give you $115,000 as an advance. It might be up front. It might be chopped into 2 or 3, and some other contingencies there. But the way that the term is, so it's not about, if you're not producing results as a producer, that doesn't mean they're going to let you go. They've paid you this, and if you haven't recouped it, there's no incentives. They're not going to release you. The only times where I see people get released, let's say, for instance, they got a deal in 2006, which, even though it seems like it's fairly recent, it was a different music market, and there was a producer who was just like amazing. He was hottest producer. She was the hottest producer. She had a couple of hits. And let's say they gave her 175, and then maybe there were some bonuses in there, extra 25. That was for the first term of the deal. But let's say in the second option of the deal, they were obligated to pay her $200. And let's say by the time that option rolls around, it's 2010. Well, she was popping in 2006. She's not popping in 2010. But maybe she's met her deliverables. And the publisher will say, you know what, I think $200,000 is not an investment we want to make because we don't believe that we're going to make it back. Then they may release you at that point. And same thing with recording deals. A label may say, listen, we know 4 years ago we promised you $100,000 advance, a $400,000 recording fund for your second album, but maybe you're not as hot anymore. Maybe we don't think that we want to make that investment because we've got to give you an advance, we've got to give you a recording fund, and we have to spend a marketing fund to promote it, so we're just going to cut our losses here. That's when you're going to see a release, generally speaking. But if you're a producer and they've paid you $115,000 and you're working, but you're not really getting results, you're just going to sit there. They're not going to let you go. Maybe in some situations based off of relationships, you can kind of, negotiate and finagle some things there, maybe. But their thing is, you're in debt to us, figure it out. We never promised you that we were going to actually help you make money. Initially what we did was we gave you a loan. We gave you a loan and it hasn't been paid back, and we don't really want to release you so that you can go and then give your records to somebody else, your compositions to somebody else. And what happens if you do start popping again? Oh, we don't want to take that risk. We just kind of want to hang around and see what happens. So yeah, that's how it usually goes. Any other questions? Yes.
problematic for Evita and West to have different publishers when they're connected to the same song?
That is a great question. No, it's not. So let's say with this song, Evita and Wesley actually did a split sheet. We decided Evita is going to get 50%, Wesley is going to get 50%, and you're going to always need 100%. If you've got a split sheet and you're coming up with 125%, you're doing something wrong. If you have a split sheet and you're coming up with 65%, you're doing something wrong. So this, let's say we've got a 50-50 split here. So my publisher is going to be responsible for my 50%. Wesley's publisher is going to be responsible for his 50%. So when a license comes in, it'll come to the both of us, and then we'll negotiate it from there. Let's say it's a $10,000 license, then we would just split that fee.
Okay. So.
Now, to the point that was made earlier about kind of like the default law, if you are a co-creator or co-writer, you're a joint owner. The way that the default law works is that myself or Wesley, we can certainly license this composition to anyone that we want without necessarily having the other one sign off, so long as it's a non-exclusive license. If it is an exclusive license, both parties have to sign off. So if Wesley decides he wants to do the license and I'm not necessarily looped in, he can go ahead and do that on a non-exclusive basis so long as I get my 50% share. In practice, though, you usually see all parties coming in on a license and giving their opinion on what they want and what the terms are.
Okay, so if one party, if the deal on the table was an exclusive license and one party didn't want to do it, then you just got to pass up that deal.
Yeah. Yeah. Yes.
How much does the deal landscape change if Star was a cover? Because they don't have the copyright
Right.
to show the song.
Right.
Is it going to change that?
Absolutely, it's going to change the landscape. So if Star is a cover, what we have here is that myself and Wesley, and as far as the production and the writing is going to be the same. The production is basically nothing original added to it.
Yeah, that'd be another twist on it, I guess. What if it's changed a little bit?
Yeah, if it's a change, that's when we start getting more into a derivative. That's when you do have to get permission, kind of more in the area of a sample, where you do have to get permission from the sample owner. But what we know from cover records, usually it's handled by that mechanical license, where it's like, okay, you cover it. From a publishing standpoint, you're just going to do the mechanical license. So here, because we haven't done anything original, maybe we're just replaying. We are not copyright owners, and that is the contingency to being a copyright owner, is that it has to be an original work of authorship, which means that it has to be original, and it has to be a work of authorship in a tangible form. It has to be written, it has to be recorded. So if I think of some lyrics in my head, I do not have a copyright, but if I think of some original lyrics and I write it down, I do have a copyright. So if we're just kind of replaying what's there, we haven't done anything original to it. But from a master standpoint, which is the sound recording, there are rights there. But on a mechanical side, on the publishing with respect to a cover, it's going to be for the original composition authors.
Do they need to get permission prior to recording the song?
Well, there's the Harry Fox, and so it's a database with pretty much every song that you can imagine. There may be some exclusions, and you go and you say, Harry Fox database, I want to cover Star, and then it's going to ask you how many copies, distributions you think you're going to make. You say, I think I'm going to do 150 units, and then you pay a fee based on that. Any other questions?
On the admin deal, right? What does that represent in terms of the catalog that you create? Is it all like catalog prior to the deal, or like it's prior and post?
That is a great question. It's a really great question. That's a point of negotiation.
Okay.
So let's say, for instance, you were in a publishing deal. You got a taste of that world. You made it out. You survived. Perhaps you were continuing to buzz. You're popular. You're very, very hot producer. And then you decide you just want to be in the admin business because you've had enough of the co-pub. You've reached a certain level in your career where you don't need a co-publisher, but you need someone to administrate. Well, what may happen? Well, chances are what you've done prior to the admin deal, you're not going to be able to take it with you in the admin deal. Now, if you are a producer and you haven't been in a pre-existing deal, but you've got a pre-existing catalog that you want to, that you want to keep, I can see an admin publisher saying, well, no, we're going to give you this money, and we want to be able to participate in revenue from your older content, because if your newer content is successful, which we're helping you to build, right? We don't necessarily want you to have a piece of catalog that is free and clear that you can then go and do other business with, and then we've got to divvy up the catalog and whatnot. So chances are it's going to be everything all up, to that point. Any other questions right now? Alrighty. So we've talked about the major deals with regards to copyright. We've gone in depth about every recording. There's going to be 2 copyrights involved. The underlying composition and the sound recording, where the authors of the composition and the sound recording, they have these natural rights, and in order for third parties to use it, whether it's a publisher, record label, or some sort of brand that wants to license it, they have to get it from the content creators. And real quick, as far as the trademark and personality rights are concerned, we talked a little bit about those things being with regards to the brand, and this is where you get into the endorsement deals. So say, for instance, you have a pop artist, and it's Dana. And not only does Mac want to use the song, they want Dana to appear in some commercials. They want her to do an ad campaign where she's endorsing the product. Maybe they're even doing a Dana lipstick. That's where we start getting into, okay, Mac, we understand that you want to use my name, my image, and my likeness. We also understand that you want to use my stage name, Dana, maybe it's spelled a little differently, in your campaign. So that's when we start talking about how much money that's going to be, any sort of exclusive rights. They may say, hey, we're willing to pay you the money, but we don't want you doing deals with L'Oreal or Maybelline. We want to have the exclusive rights with regard to your name, your image, and your likeness, and even your trademarks with regard to cosmetics. And this list can go on. Shoes, shirts, bags, whatever the case may be. Beverages, beer, wine, PepsiCo. That's where we start getting into the endorsement deals, merch deals. Somebody wants to help you develop a merch line, maybe some sort of strategic alliance with your existing t-shirt line, and that's where we're getting into the same things. And so we've covered the rights here. We're going to go quickly as we can into music streaming. And I think it's important to note music streaming. I don't think that any of us in this room can afford not to be a student of what's happening with music streaming. My position is that the biggest thing with music streaming is the value of the copyright. So we've gone in depth about what a copyright is, exclusive rights, all the things you go through for a recording deal, licensing, music publishing, all of those things. And we know that copyright is the staple of the music business. But then when it comes to music streaming, what music streaming did was it took the power, well, it definitely dates back to Napster. But what it did, it took the power out of the hands of the record labels and the publishers to dictate to consumers how they were going to consume. Because music streaming is the way, and we're not going to go back, like ever, because of the consumer demand, what's at stake here is the value of the copyright. Because we know that copyright is what it is. But what we also know is that a stream, I don't know the exact number, 0.000 something, something, something. As opposed to a digital download, maybe it's 99 cents or like $1 and some change. So when we talk about the value of a copyright, it's like, I know that I have these rights. I know that I'm in control here. But am I really in control? Well, music streaming is the way, and the value of my work seems to be dipping because of the way that people are consuming. So it's an ever-evolving piece with the music streaming. We see more companies getting involved in the music streaming business. Of course, you've got the Spotify, you've got Apple Music, you've got Tidal, you've got SoundCloud. WeTransfer, if you're familiar with WeTransfer, it's a platform that allows for you to upload large files. Well, they're now getting into the streaming business as well. Streaming is not the service that they're offering, but they're going to start using streaming of exclusive content to attract people to their platform. So what the struggle here is, if I am one of the owners in the two copyrights, and music streaming, as we can see here, doesn't compare to an actual digital download. I don't have an issue with digital downloads, although there is some sort of sacrifice when it comes to album artwork, as someone mentioned earlier, liner notes and things like that. What do content creators, which are going to be your songwriters, producers, your artists? My big question is, especially for songwriters and producers, how will they live? How will they survive over time? And a lot of people are saying, well, a digital download is 99 cents, not everybody's going to buy it. You get a gajillion streams over time, maybe it can pan out, maybe. I actually read an article where it posted the number of the most streamed song of 2015. I can't remember what that number was. It was for an act that I was actually surprised that it was that act, but it was still relatively low. And I ran through the math and all of the numbers, and it still wasn't working out. And if I'm a songwriter or producer, I don't care what I can make over 15 years. I want my money now, so that I can invest it, I can make a living for my family, and perhaps create content and not have to have a day job. So I think this is very alarming. I could do a whole discussion on this. I'm very concerned about this, and I think that if this is not balanced out immediately, it will disrupt, and it is disrupting the ecosystem of music, because you have these streaming platforms, and they're still trying to figure out how to make money, how to get their business model together, but there's definitely some money being generated, and they've got all of the eyes and ears. I can't count ears. And then you've got the labels and the publishers, which represent most of the catalogs that are being streamed. There's a significant independent audience as well that's using aggregators. They're going to always figure out how to make money. They've got shareholders and stakeholders and bottom lines and things like that. They're going to always figure that out. But the content creators, I don't know who's really fighting for these guys. And I don't know what their position is in this conversation, or if they're even being included in the conversation. So as future music attorneys and people who are involved in the music space, we have to pay attention to this. We have to be a student of this. And I certainly challenge us all to figure out what some resolutions will be, and start talking to other people in the music community about what can be done here and making sure that we're really paying attention to it. So that is my spiel. Any questions at this time? Yes.
So how do the platforms for music streaming get licenses and permission to use these songs?
Great question. So we do know at some point Spotify was not getting permission. And I actually remember sitting at a luncheon where Daniel Ek was the guest speaker. It was during Grammy weekend. And there's two things that I walked away with. The first thing was, he said they did not understand the rights that were involved. I found that to be mind-blowing. It's like the very thing that you're offering, you don't know the rights. Okay.
This is the founder.
Yes. The second thing is that I found a bit empowering is that you don't have to know everything to get started and to make an impact. So that was definitely my takeaway, because at that point, before Spotify started talking to the labels and publishers, having serious conversations, Spotify was owning things. Didn't know the rights or whatnot, didn't know, so they say. So I guess it's kind of cool looking at it from that angle, but from a content creator standpoint, not so cool. So ultimately, what will happen with the platform is the platform will say, okay, we understand in order for us to do what we're doing, we do not naturally own these rights and that they belong to people. So we understand that we have to be in business with publishers for copyright number one, and labels or parties that own the sound recordings for copyright number two. And so then they talk about, what those fees are going to be. But, here's the thing, and when we talk about content creators, where are they in the discussion? What we do know is that platforms like Spotify, they will cut a check. The publisher and the label will get ad revenue participation. And they also get equity participation. What I can tell you is that this most likely does not trickle down to the content creator. So what we have here is a question where perhaps the value of these rights was at this level, but the platform came in and said, we can pay you a fraction of that, but to make up for the other fraction that we're not able to give you, we can give you these things. And the publishers and the labels said, oh, that sounds great, even though the content creator doesn't participate in it. So it goes back to what I said before. Labels and publishers will absolutely make their money. But I can't say for certain that the content creators are participating in that. So there is a licensing fee that's being paid, but the value of that is what's questionable, because the licensing fee does trickle down. But if it's not the full value, but the balance of that value is made up here, but on revenue streams that don't trickle down to the content creator. Very problematic. It's like the biggest non-secret secret. It's a huge issue. It's my soapbox.
Fiduciary issue?
It's a bit fraudulent, yeah, absolutely. Yeah, it is. Yes?
What are your thoughts on the future of that from the standpoint of the content creators being the little guys and being basically cut out? How do you feel that they could be cut in? Is there a way?
Absolutely. Make a way. I think what it will take education. It will take the big guys on the content creator end to kind of raise hell about it as well. It might take a class action lawsuit. But I think as of now, there isn't a lot of education about it. I don't know what my colleagues are doing, what kind of conversations they're having with their clients. This is something that I definitely talk about, and I'm known for trying to work these in on publishing deals and recording agreements. And I've been rejected, but you will see this in my deals on behalf of my clients, because I know it's something that they are participating in. But I think it's an education. I think it's gotta go to whistle. It has to be one of those things, because as of right now, I don't know that the content creators are aware or fully understand it. And so I think that's just what it is. A union of sorts, but there has to be a collective effort that says, hey, by the way, we see what you're doing, and it's a little bit fraudulent. And we don't necessarily like it. Now there is I think it was a major publisher recently. Oh, I can't remember who it was. And they're going to create, there's already this system, but they're going to implement this system of transparency, where the songwriters, or I can't remember if it was a publisher or record label, where the songwriters or the content creators can now see how many streams they're getting and how that money is working. My whole thing is it's not about the stream. I mean, that's important. I just think ultimately with the stream, the streaming royalty rate has to be higher. It's about all of these things. Are you going to put this in your transparent database so that we can see it as well? What they're making here and the $0 that we're making as well. So my thing is, there are going to be efforts to be transparent, but the basis on which transparent is defined, or transparency is defined, I think is it's very ill intent and it's not transparent. So yes.
Are the laws of copyright and music streaming and publishing in general the same, like overseas as well?
So overseas, so here we talked about the copyrights and how we have the United States Constitution. Overseas, there are some countries that do have this idea of the two copyrights. There are other countries where you may have mass consumption of music, but it might be more of a bootlegging. It might be a system where they don't really honor it. So the idea of music as a property, I guess to say generally speaking, it's recognized globally for the most part, but then you have cultures and societies that don't necessarily honor it.
I can see how, I guess whoever the founder of Spotify wasn't aware because it was founded in Sweden.
Yeah, that's exactly right. So, well, I don't want to give him an excuse because he came over into a territory. You got to do some due diligence there. I mean, it's the United States of America. We got all kinds of stuff going on, rules and regulations and laws and whatnot. But to your point, absolutely, because his position is that in Sweden, the pirating was at an insane level that what he wanted to do was to create a platform that reduced that to some extent. So even now, when you read anything about Spotify kind of trying to protect its position, they're always going to lead with, hey, but we're keeping people from pirating music. That's always going to be their position. As opposed to kind of my angle from where we started with music and the strength and the value of a copyright and the systems that we had eventually to music streaming, but from a Daniel X Spotify position is we saved the day. We have put a system in place where people are paying for it, even if it's at this rate. So therefore you all should be thankful and give us time to allow for the rates to kind of balance out over time. And that was the position they took when Taylor Swift pulled her music. It's like, oh, we don't really, agree with that. Not only have we given her an opportunity to be heard by her fans and for people to discover her music, we're really here to save music. Because before we got here, everybody was pirating music. I think that's a great point. Yes?
Can you speak to the point where the major labels are now starting to purchase the aggregators under separate names? Like because I think like a lot of content creators go in under aggregators, like, oh, I need my music on iTunes, but they don't realize that now it's backdooring a deal, and you don't even realize that it's happening. Like, what is your opinion on that?
Well, my opinion on that generally is that from a big label publisher standpoint, you're going to purchase an aggregator because you've got more content, you've got more in the system, you've got more shots at the pot of money. I don't know from a aggregator user deal, I don't know what the change will be in that. But from an aggregator standpoint, I don't know particularly what aggregators. So let's say, for instance, TuneCore, right? Well, TuneCore in and of itself is just making a lot of money.
Right.
So perhaps the big guys can come in and say, listen, you can stay as an aggregator, you can still look independent, but we want to give you additional support, maybe additional funding to be able to participate in whatever it is that you're doing. So ultimately, I think it comes down to labels and publishers just wanting to generate more revenue.
I was just going to ask about YouTube streaming things,
Oh, God, yeah.
but I know it's a whole nother thing. We're kind of running out of time, so.
Yeah. So with YouTube streaming, I look at it a little bit differently than, I'm not all the way mad at YouTube streaming. YouTube is certainly evolving to become, it is a beast. It's totally a beast. And one of the biggest ways that people consume content, and people do have the ability to post content and whatnot, they'll pull it. My issue with particularly something like a Spotify is that if an album comes out, you can go to Spotify and listen to it for free. As opposed to a YouTube, where people find ways to upload albums. People aren't going there necessarily to listen to a full album. I don't like the spirit of a platform like Spotify, which is music should be free. Who created that culture and why? Why should music be free? And I think that's what it promotes. It's like, oh, but we have an option where people can pay. You know, I don't buy it. So with YouTube, there's certainly there's streaming value there. People get checks from it. They do have I don't know the name of the program, but if you're independent, you can partner with them, and there's a whole system in there. So it's starting to become, not even starting to become, it's a big moneymaker. Whether you are on streaming and there's ads on it, or you're now getting endorsement partnerships as a personality on YouTube, you're getting a show off of YouTube. When I was in LA in February, YouTube, someone had told me that YouTube had bought blocks of property where they're going to basically turn it into just like a production stage, just like a studio, and they're going to have people come in and create original content.
Yeah, several.
Yeah, so it's a thing. But even there though, I think it's still an evolving, how do we make money from this? We as in content creators and not YouTube. And then if there's music up there, how do we make money from this as the content creators and not the labels and the publishers that have gotten in on this and like, listen, we're gonna start pulling music unless. And so now you can have a little Susie in Denmark do a cover song or whatever, and it'll be up there. It's just that people are getting paid for it now. Yes.
So 3 different instances. So we have Kanye, who directly did not want to put his music out on the streaming subjects, and then only releasing it through Tidal, and then kind of his circumstance. And then you have like Beyonce releasing her album where it's available on iTunes, and then she maybe has one song that's available to stream.
Right.
And then you have just a regular artist who has a regular release, and then it's available immediately to stream. What are the differences in their options for that happening? Is it just the negotiation between the label and the publishing and the streaming company?
I don't know what's happening with Kanye. And I'm sure his label is just like, but the whole title thing is very interesting because I read somewhere that it had been streamed 250 million times. But what my question is, how are the songwriters and producers going to make out on that? And I actually know a guy who produced on that, and I will be asking him in like 3 months, what's your check looking like? Because when they released it, I was like, oh my God, I'm really proud of you. But all I kept thinking was, what's this check going to look like? Because let's say, for instance, it wasn't streamed 250 million times. It wasn't even bought 250 million times. What if it was a fraction of 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 that was bought? I just think the songwriters and producers would make out better. So it's like, it was streamed, people heard it. What does that mean for my ability to create music and make a living? If you're a producer, do you really care that everybody's listening to it and you can't eat? You can't feed your family? That's not cool. But Kanye can tour, he can do endorsements, and he can do crazy things. I love Kanye, huge Kanye fan. But he can make his money other ways. So then it's like, okay, you put it on Tidal. What prior discussion did you have with the people that helped you make this album, if any?
Right.
I can understand why he wants to throw it on Tidal. It's a brand positioning thing for him. It's a tool. But how are the content creators outside of Kanye, how are they going to make money from it?
I feel like he devalued the art by just doing that and not necessarily just releasing it to where people could buy it and possibly stream. And now he just released, a track in order for people to stream. But after a month later, like the hype has died down, like all of that is gone.
Yeah, and again, I think, when we're using Kanye as an example, and maybe it just makes it a unique example, I don't think it matters for him, but from the spirit of music, right? It definitely matters. Which is why I absolutely applauded Adele when she says, for the first couple of weeks, I'm not going to stream my album. You will buy it.
Right.
And people did. And the people who helped her create their project, they will benefit from that greatly. Another thing that I have started doing in my deals is trying to put my clients in a position who are artists to be a part of the decision-making process as to whether a release will be initially released on a streaming platform. We'll see where I get with that. But I think it's important. I'd like for my clients to say, hey, let's hold back for 2 weeks. Let's do digital downloads, physical sales if we want to do physical sales, and then we can put it out in 2 weeks on a streaming platform. As far as Beyonce, she went straight to iTunes.
Right.
People bought that.
Exactly.
That's what you do. That's what you do. And then there was, you said, just kind of a growing artist who may have just kind of released on streaming. I personally don't know the value or the rate at which people are being discovered on a Spotify or a platform like that, and then people continuing to engage or search for that talent. I don't know how that really works, but I know that is certainly an argument that people like to use. You want to stream it on Spotify, you want to stream it here because that's how you'll be discovered. That is certainly where the streaming platforms are going to come from, and I don't know what the metrics to that is. It could be true, I don't know, but just every time they say that, I don't really have the data to say, oh, Tim and Tom and Jake, they were unknown artists and they released on Spotify, and then 2 months later, all of a sudden, I don't know. I do know of a band that used an aggregator to get on Spotify. From one song, they've made, within the last maybe year and a half or so, 25,000, 30,000. So, and then you wonder, are independents just making out better? Yeah. We had a question. All right, I think that is it. If you all have any questions, well, I hope this is helpful. Thanks for coming.
Thank
Ask
you so
questions.
much.